the abuse for the way they abuse their office, because they abuse his civil rights left and right here, and that you start getting the judge put the state on the defensive, where they have to defend all of their egregious conduct, and tell them that when you talk about day of reckoning, that could be a civil suit in favor of KyleRittenhouse based on their misconduct. At least throw it out. You can throw it out there as to how to sort of frame for the judge how bad their misconduct has been.
Can we focus on
misconduct? If it quacks like misconduct.
Can we focus on the fact that the judge says, I've forewarned you, I've told you, this is a house of cards. There's a day of reckoning coming. Heavier. And guess what?
Oh my God! All you have to do is echo it back.
No, let's back off the request for a mistrial with prejudice. Let's go without prejudice to show that we're being collaborative, and so that Klaus over there, Kraus, all that he has to do is say we oppose that, so that Your Honor, if you grant it, we get to have another prosecution later on. Just terrible.
This is insanity. I mean, whether or not you're screaming in the courtroom or standing up and calmly saying, Your Honor, this is a mistrial. This is a mistrial with prejudice. Of course it is. You've known it is. You've indicated that it is. You've said they've acted in bad faith. You've been queasy about this. And as the state keeps talking, your queasiness keeps growing. And that's because this whole case stinks, Your Honor. It stunk from the start, but we knew once this footage came in late, without notice, and they gave us the wrong file, which cannot be done by mere happenstance or glitch. But required someone to mess this up. How convenient that this is the one file in the entire case that's messed up at this point in the case, and it just happens to be the one file that the state's entire case hinges on at this point, because every single other aspect of their case has been blown out of the water. Mistrial this, Your Honor. It's obviously prejudicial, and the state wants it to be prejudicial. You've got it. Yep. They've got to just ask, and the judge, I think, is waiting for them.
Are focused on the judge. A judge in this kind of case, most cases, looks to the defense lawyer's passion, their degree, their intensity for cues and clues. So often they'll think you as a defense lawyer are raising emotions solely to preserve your appellate rights, that you're not really wanting the judge to grant it, that you want the judge to deny it, so you've got a nice little escape valve on the backside. And that's easily what the judge could be interpreting the defense to be doing here. That unless they're screaming, unless they're over the top, unless they're demanding constantly, unless they're demanding insistently, unless they're talking about how this has now prejudiced the jury, we now see that, we're witnessing this, and how this deliberation is going and what they're asking about. Unless that happens from the defense, the judge is going to take it as, oh, you really just want to put down this in the record and don't really want me to do this. And that's the problem with it. This is more on the defense than it is on the judge, though I'm not excusing the judge not taking action.
Well, I'm not sure why they held themselves back when Kraus was going on his soliloquy. You could see both of their brows being raised, and they're kind of holding back. At that point, get into a brawl. Show that right now, because I felt it. I'm not involved at all personally with Kraus saying what he's saying, with excuse number 9 or 11 as to how this happened, throwing random people in the crime lab under the bus, throwing everybody possible. He threw Binger under the bus halfway through one of his excuses until Binger's like, what, bro?